When I was new to the dependency system, I really didn't understand why I needed to know all of the kind of soft, feely, touchy stuff that the caseworkers do. After all, isn't it their job to understand the social work part of this? Well, what I learned was, in order to do my job well, I have to have a basic understanding of what the caseworkers do. For example, my husband, who's also an attorney, who does not normally do personal injury cases, received a case where he had a client that had a huge head trauma. He spent hours, if not days, researching about head trauma so that he could properly depose doctors. It's what we do in every other area of practice, so why not in the dependency system as well? So even though you need to be aware of the laws and the rules of procedure, you also need to be familiar with the practices and the guidelines that the caseworkers follow. Next, you're going to hear from Christy Stanek, who is really an expert in this area, as she guides you through safety threats and all of the paperwork and maze that caseworkers have to work on every day.
I'd like to talk to you today about some terms that you're going to hear in court. Safety assessment and planning and family service plans. And prior to the bulletin on safety assessment, decisions were made very inconsistently across the Commonwealth by caseworkers. Oftentimes decisions were made based on perceptions, what that particular individual felt was appropriate and not appropriate, safe and not safe. And as you can imagine, there was inconsistencies across each county and across the state. So Pennsylvania recognized that and issued the Safety Assessment and Planning Bulletin. And what this did is brought consistency to decision making. Why is this important to you as a guardian ad litem? The importance to you is that every decision on whether or not a child should be placed is made based on the safety assessment. So as a guardian ad litem, when you're in court and you're representing your client, it's going to be important for you to ask to see the safety assessment prior to the hearing. Review the safety assessment. Look for things called threats. And what a threat is the caseworker's assessment of danger to the child. A threat ultimately equals an unsafe child if it cannot be controlled. Threats are serious, they're immediate, they're observable, they're out of control, involving a vulnerable child. So threats are something that cannot be controlled by any other mechanism. There's safety assessments that are standard across Pennsylvania that counties use, and when a caseworker completes the safety assessment, they'll indicate whether or not there's a threat to the child. Now, if there's a threat to the child, does that necessarily mean that the child has to be removed? The answer to that is no, and that's where the safety plan comes into place. So what you want to ask a caseworker prior to the hearing is to see and review the safety assessment. If you see a threat, you want to ask if that threat can be controlled with a safety plan. Why is that important? Because oftentimes across the Commonwealth, the agencies are still adapting to this new decision-making form. So it's your role as a guardian ad litem to make sure that your child has been assessed fairly, accurately by the agency who is doing those assessments. And by asking to see the safety assessments, by cross-examining on the safety assessment, and by asking if the plan would control the threat. Ultimately, what you will be doing is challenging whether or not that child needs to be in placement or can stay at home with an appropriate safety plan. Another critical element to safety assessment and safety planning are the protective capacities of the guardians, the parents caring for the child or children. It's very important that you ask about the protective capacities of the parent. Protective capacities are the natural ability for a parent to protect their child, often involving cognitive components, behavioral components, and emotional components. So what you want to look for are things like, is this individual bonded with the child? Do they have a positive regard for the child? Are they aligned with the child? Or are they aligned with the alleged perpetrator? These are critical questions for you to ask when looking at protective capacities, because protective capacities often give you an indication of whether or not the parent can protect the child in the home with a safety plan. The next term that I'd like to talk to you about is more traditional planning that has been around in Pennsylvania for quite a while, and it's what you're going to hear called the Family Service Plan. The Family Service Plan is the plan that is developed with the family to identify the areas that need to be resolved in order for the family to end their involvement with child welfare. Family service plans should always be developed with the family. No longer should we see cookie-cutter family service plans that spell out the same services for every family that comes through the door. Family service plans need to be individualized. Families are individuals that have individual needs, and there are individual resolutions to those issues going on within the family. So as you look at your family service plans, if you see things like we'll attend psychological evaluation, we'll attend psychiatric evaluations, we'll attend drug and alcohol, we'll attend parenting classes, we'll attend in-home services. These are the types of cookie-cutter family service plans that we do not want to see. It does not individualize the plan, certainly doesn't give the family measurable goals to let them know when they have resolved the issues at hand. So it's critical when you look at family service plans to challenge what are the measurable goals in behavioral terms so that your client knows what they need to resolve. For example, if you're representing a child and they have drug and alcohol issues, what you would not want to see on a family service plan is that the child should attend drug and alcohol treatment and follow through with all recommendations. You would want to see something measurable, something behavioral, that the child would know what they need to do in order to get that resolved. So for example, you would want to see something along the lines of child being able to identify their triggers, that the child would identify the individuals that they use the drugs and alcohol with, and identify separate peers that they might be able to get involved with. You would want to see them actively participate with their groups at treatment. Rather than simply following all recommendations, you would want to see some specific behavioral recommendations that could be measured, so that when you go to court, that you could share with the judge that the child is hanging out with a new group of friends, that the child now understands that the triggers for them happen on Friday and Saturday night when their friends call, and now they have put a plan into place to address that. So you would want to see something behavioral, you would want to see something measurable, so that you and your child know when that issue is resolved.
Family finding is the opportunity for the agencies and all the stakeholders involved in the lives of children to make sure they have positive connections. Family finding is not so narrow to be just the opportunity to find a mom and a dad, or to find someone for the child to live with if they cannot be safely with their mom and dad. But it really is broader than that, and it's about finding connections, positive connections for children. And we know that the more positive connections a child has, the healthier their life they can live, to have that many supports and people caring for them and about them. So the role of a guardian ad litem really begins with asking that question: has there been a family finding done? And you might run into people who say, oh no, we have a mom and dad, we don't need family finding. We ask you to go beyond that. We ask you to go beyond and say, but who will be in this life of the child once dependency is over? And how do we build positive supports in the life of this child? So as guardian ad litem, you want to be asking the question, have we done it? And be persistent, because it is a best practice, and we know that there will be life beyond the dependency system for this child. So where will they have Christmas? And who will send them a birthday card? And who will care that they graduate from college? Will there be more than 2 people there? And so that's really the role of the guardian, is to trigger that and prompt that we build that for the child for beyond the years in the dependency system, or even the short time they're there.
It's interesting because so many people have said to me they have tried to define what is family. And you know what? Family is not for us to define. Family needs to be defined by the child. Who do they believe to be their family? By the child's parents. Who do they believe to be family? And part of the process can be saying things like, where did you spend last Christmas? Who was there with you? Tell me about an event in your life that you really had a good time and who was there. So again, it is not up to us in government to define family. As guardians, it is so important for you every time you meet with the caseworker to ask the question, have you found family? Have you found family? Asking it once is not enough. You should also be asking the child, do you have any family members that can be a resource? Do you have any family members that you spend time with? It is critical that children are kept with family whenever possible.
Family group decision making is maybe one of the most powerful tools that we have within the dependency system. It's more than just a process. It can be a philosophy and a way of life. It is a way to help families develop the ability to make decisions for themselves and to no longer be dependent on a system, that they feel empowered to make their own decisions, because safety for the child is best met by the families who know themselves better than anyone else knows them. So it may feel a little counterintuitive to have families in the dependency system that are there because they haven't made good decisions or they haven't been able to keep a stable life. And it may seem counterintuitive to give the power back to them to make the decisions. But the opportunity is there for them to know themselves in a different way and to work together in a different way that could bring about a different result. And we know with family group decision making that that happens. And that's why it is one of the recognized best practices. Guardians ad litem can be involved with family group decision making in two ways. One would be in the fact that you actually ask, can we have a family group decision making in this family? Is this an appropriate time for a family group decision making? Again, front loading the system with this type of work so the guardian's role isn't necessarily a litigant in a courtroom. The second way would be if you are invited to a family group decision making, which is the only way attorneys can participate. It would be a very great honor to any guardian, because that means that you have been identified as a person that has a heart, hand, or mind on the life of that child to the degree that the family recognizes you as someone who could contribute to helping to find a way for this family to work together. So in either direction, you play a very, very important role with the promotion of family group decision making. And family group decision making is very, very important to the role of the guardian ad litem to make sure that that tool is used for this family, if at all possible, in creative ways. Very, very important to any child to maintain a level of contact with their parent even after they have been placed out of the home. Not just the parent, but the siblings as well. We know from all kinds of research that it is very important to the success of a child if they have continuing contact with their parent, even if the parent's incarcerated, even if the siblings are placed in a different home. Very, very important for that contact to continue. Otherwise, we're creating more trauma, more grief and loss with the child that interferes with any positive forward movement of the family. So making that visitation, one, common, and the guardian ad litem is playing that role, making sure how often will this child see their parent, and insisting on it if they really don't see the agency really coming to the table and providing it. We have minimum standards on the Department of Public Welfare. Nothing says that it can't be more than that. And so the role of the guardian ad litem would be maybe pricking the consciences of the court, of the caseworker, of the supervisors to ensure that the contact happens. And not just any kind of contact, but as natural contact as possible so that the family is not in a sterile room, but is really looking at safety issues only. And if you can safely have visitation in someone's home, always the least restrictive alternative. So this family can feel like a family, even if they're not together, even if they have problems and things need to be worked through, they still have the benefit that they have each other. And they have the pieces of each other that are safe, that are loving, and promoted. And the guardian can play a very important role, and maybe even asking the child, Who would you like to see? Who is important to you? Who listens to you? Visitation might not be the parent. It might be the grandmother. It might be the aunt. And you won't know that unless you ask the child, and that plays a very, very important role in that child's life and getting them through a very difficult time. It is important that visitation take place between siblings as well. And we've often found situations in our experience where it's just impossible for all 4 children to be in the same home. You also have different family members because you might have different fathers or different mothers, and so different family constellations are available to take the children. And when we are promoting kinship care as the first placement, sometimes those tough decisions have to be made. Does this sibling go with the father's parents, or does this sibling go with unrelated individuals just so they can be with their siblings? Those are tough calls to make, but in many instances we find that siblings for various reasons cannot be together. And when that happens, then visitation between siblings is very, very critical as well. Often if there's been dysfunction in their family, all they've had are the siblings and that commonality between them. They've borne a lot of experiences together. There's a certain comfort that comes from that. So making sure that it's not just the visitation with the parent and the children, but the siblings themselves. And we really encourage, and we've seen a lot of foster homes really step up to the table that way, and relatives and kinship care meeting together at McDonald's just so the kids have time together. So it doesn't have to be formally all the time with case aides and take their time. Really promoting and asking, can the foster parents get together? Can the kinship care folks get together? So these kids have time together as much as possible. Very, very important to the security of the children to know that they have each other. When you have placement, which is necessary for the safety of the children, you cannot always have siblings together. It's just not always possible, but that should always be the first choice. And the guardian has a perfect role because you represent all the children. Even if they're placed in different places, you represent the children in many instances. And so having a concern about them as a family and making sure that you, again, prick the conscience of the agencies and providers to ensure that these children have time with each other. Sometimes adoptions even take place, and as a guardian ad litem, you would want to make sure that Act 101 is honored and that people understand that even though their children's lives may go forward in a permanent nature apart from one another, they will always need that connectedness and that contact, particularly when they're older and remember that they had a life together. So as a guardian, really, really championing that cause for the children can make the difference between maybe a lifetime of grief and loss and depression, which would not be necessary otherwise. Maybe one of the most understood, I've been a judge for 25 years and I feel badly that I haven't learned about grief and loss until about the last 5 years. And much of what I've learned about grief and loss has come to me through my practices in adult drug court, because my experience there has been that I've seen the damage of unresolved grief and loss in adults. And that's what has clued me in of what a priority it has to be at the front end when children are going through these experiences through the dependency system. So we have science now, we have research, we have the ability to understand grief and loss. And when we don't address it, we create insecure souls, we create people who do not feel connected, people who do not understand themselves what effect grief and loss has had on them, and they continue to just crash and burn, pull themselves up, crash and burn from the unresolved grief. And it is a great disservice for us not to front load at the beginning. And as a guardian ad litem, you have a great opportunity to know children and to know and experience and listen to what they're missing. And they could be missing their teddy bear. They could be missing just the smell of their bedspread at home. It might not have been the greatest bedspread, but it was theirs. And so as a guardian, early on in the case, asking, what does the child have from their past life? Was there anything brought from their home with them, a particular book? And maybe a cup they like to use, and learning that as a guardian, asking the child about that regardless of their age. you might be surprised at what you learn of what could give comfort to this child. And that, just that minimization of grief and loss can make a tremendous difference in how they cope and learn and have success otherwise in school, or maybe even in that foster family. I know that sometimes we hear about bad behavior in a foster family, and we often think the child needs medication, or maybe the child needs a psychiatric or psychological evaluation. But as a guardian, if you can start with the why, and are they dealing with grief and loss first, you might be surprised how much you can ameliorate the situation by simply asking that question and tuning in. Otherwise, we do more harm than good. The most important thing you can do as a guardian ad litem for your child is to believe in them. Believe in them and believe in their family. And believe that every family has strength. You might have to look for it. You might only start with one. And you might only start with progress, not perfection. But believing in the family makes all the difference. You will feel better about your work, and the family will feel better about you. And always remember, when you help the family, you help the child.